All right, everyone, settle in. Welcome to class. Today, we are cracking the code on one of the most powerful, and let's be honest, most misunderstood, articles in the entire Indian Constitution, Article 14. We throw the word equality around all the time, but what does it really mean when the law itself is put on trial? Let's dive in. So, what does this right to equality actually mean? We all think we know, right? But turning that feeling into a concrete legal principle, well, that's a whole different ballgame. What happens when you pit this idea against the immense power of the state? Let me tell you, the answer isn't some simple dictionary definition. It's this incredible, evolving story of how our very idea of fairness has been shaped by the courts over decades. Okay, here's our roadmap for today. First, we're going to look at the exact words, the equality clause itself. Then, we'll see how it's actually two sides of the same coin. From there, we'll get into the nitty-gritty with something called the classification test. Then, a huge plot twist, the battle against arbitrary power. And finally, we'll tie it all together with a concept called the golden triangle. Ready? Let's get started. Okay, rule number 1 in law, and I want you to remember this. You always start with the text, the precise, specific words. This is our foundation. Everything, and I mean everything we're going to discuss today, is built right on top of this single sentence. And here it is, Article 14. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Now, I want you to laser focus on two phrases here. First, equality before the law, and second, equal protection of the laws. Now, you might think, Professor, isn't that just saying the same thing twice? Nope, not at all. These are two distinct and incredibly powerful ideas packed into one clause. And notice the word they chose, person. It doesn't say citizen, and that, my friends, is a huge deal. Unlike some other fundamental rights, Article 14 is for everybody. Citizens, foreigners, anyone. As long as you are physically within the territory of India, boom, the state owes you this duty of equality. So let's get back to those two phrases, equality before the law and equal protection of the laws. The best way to understand them is to think of them as two sides of the same coin. One is what we call a negative concept, and the other is a positive one. Sounds a little academic, I know, but stick with me. It's actually pretty simple. So equality before the law is the negative part. And why negative? Because it's about the absence of something. It tells the state what it can't do. It says, hey state, you are not allowed to give anyone special privileges. No one gets to be above the law. On the flip side, equal protection of the laws is a positive command. It's an instruction. It tells the state, you must treat people in similar situations in the same way. It's an order to take action. And this two-part structure is basically a mashup of two different legal traditions. Equality before the law, that's an English concept from a legal scholar named Dicey. It's a negative idea. Don't play favorites. But equal protection of the laws, that's an American import from their 14th Amendment. And that's a positive command. You must treat like alike. The genius of our Constitution is that it took both of these ideas and combined them. But wait a minute. This raises a pretty obvious problem, doesn't it? If like shall be treated alike, does that mean you have to treat everyone identically, no matter how different their circumstances are? I mean, should a millionaire pay the exact same income tax as a daily wage earner? Of course not. That would be completely unfair. And the law gets this. Absolute mechanical equality isn't the goal. This is exactly where the courts had to step in and get smart. See, Article 14 forbids something called class legislation. That's making a special law for a specific group without a good reason. That's a huge no-no. But what it does permit is reasonable classification. So the million-dollar question becomes, what counts as reasonable? Well, to figure that out, the courts came up with a test. And this test really took shape in a landmark 1952 case, Anwar Ali Sarkar. So here's what happened. The West Bengal government set up special, faster courts. Sounds good, right? Who wouldn't want speedier trials? But here's the kicker. The law gave the government total power to just pick and choose which cases and which people went to these special courts, with no clear rules. And the Supreme Court said, hold on a minute. You can't just create a special, potentially biased legal track for some people based on your whim. And that case gave us what we now call the twin test. It's called that because any law that classifies people has to pass both parts of this test. Not just one, both. Part 1, is there an intelligible differentia? I know, fancy legal jargon. All it means is there a real, common sense difference between the group you're treating specially and everyone else? Part 2, is there a rational nexus? In other words, does that difference have a direct, logical connection to the goal of the law? If the answer isn't a firm yes to both, the law fails. Now, for about 20 years, that twin test was the gold standard for Article 14. But then the Supreme Court started to see a problem. The test was great for checking if a law was fair. But what about a single government action? What if some official does something that's just totally random and irrational, but it doesn't create two neat classes of people to compare? The court realized equality had to mean something more. And the turning point, the real game changer, was the 1974 case of E.P. Royapa. Here, you had a senior civil servant who was transferred. On paper, it looked like a similar job, same rank. But he argued it was a meaningless, empty post, basically a punishment in disguise, done out of pure malice. His argument was simple. This action isn't based on reason, it's just arbitrary. And the court listened. They realized this was a whole new way of looking at equality. And in that Rayappa judgment, Justice Bhagawati wrote a line that literally changed Indian law forever. He said, "Equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies." Just think about that, sworn enemies. This line created a powerful new doctrine. From that moment on, any state action that is arbitrary, based on whim, not reason, is inherently unequal. Suddenly, the protective shield of Article 14 got a whole lot bigger. This brings us to our final and maybe most important concept today. The fundamental rights in our Constitution don't live in little isolated silos. They're not separate. They talk to each other, they support each other, and the Supreme Court gave this powerful idea a name: the Golden Triangle. This principle was cemented in the famous Maneka Gandhi case. Her passport was impounded by the government for no reason at all. The court ruled that you can't test a law against just one fundamental right in isolation anymore. Instead, Articles 14, 19, and 21 form a single unified shield for our liberty. Any law that restricts your freedom has to be fair under Article 14, reasonable under Article 19, and just under Article 21. All three. These are the three pillars. Think of them as a three-legged stool. Article 14, is the law non-arbitrary? Article 19, does it respect your fundamental freedoms? And Article 21, does it follow a fair and just procedure? They all have to stand together. An attack on one is an attack on all. This was a revolutionary shift in how we protect liberty in India. So we've seen Article 14 grow from a simple rule about treating people alike to this massive, powerful weapon against any arbitrary action by the state. And this leaves me with a final thought for you to ponder. In our modern world, where the government is involved in nearly every part of our lives, is this fight against arbitrariness, against pure randomness, the new, most important frontier of equality? That's something for you to think about. Class dismissed.